Key real estate vocabulary words you have to know to pass your real estate licensing exam. Let's get started. Hey everyone, if we're meeting for the first time, my name is Paul Vacheski. Welcome to the Real Estate Classroom YouTube channel. My mission is simple: to help you pass your real estate exam the first time. Okay, today we're going to do key vocabulary words you have to know for your real estate exam, number 126 through 142 of 300. The first one is 126, general warranty deed. Now, a general warranty deed can also be known as a warranty deed, depending on the location that you're doing business. Okay, it's a document that transfers title or ownership. Remember, title in real estate means ownership, from the grantor, which is the seller, to the grantee, which is the buyer. Now, a general warranty deed provides the absolute greatest level of protection for the grantee, which is the buyer. All right. The grantor warrants or indemnifies, if you will, that property's entire history. Meaning indemnification, meaning that it will reimburse or make the buyer whole if the buyer suffers damage as a result of a title defect. So it guarantees the property is free and clear from any title defects or encumbrances, no matter when they happened and no matter under whose ownership. All right, very important to remember this. So if I'm the current owner of this property and you are buying my property, what I'm going to do when I give you a general warranty deed, what I am stating as the current owner, that if there are any title issues, such as liens or any encumbrances that pop up after you and I close on the property, so that means you're the new owner. So if, let's say, a child support lien pops up 3 months after you purchase the property from me, but that child support lien goes all the way back to 1950, which is 5 owners ago. Because I gave you a general warranty deed, I'm going to indemnify you or make you whole, meaning I'm going to end up having to pay that lien off because of the type of deed that I gave you, which was a general warranty deed. Okay, the next type of deed I want to discuss is a special warranty deed, or sometimes referred to as a limited warranty deed. Now, I'm not going to go into great discussion because I just described to you what a general warranty deed does. A special warranty deed does the exact same thing as the general warranty deed, with one exception. The grantor will give no warranties and no indemnification to the new buyer for any claim that has arisen before the grantor's time that they acquired title. So, I'm the owner, you're buying my piece of property. I've owned this piece of property or held title to this property for 20 years. If I give you a special warranty deed, what I'm saying is I will indemnify you or make you whole for any issues that pop up or any claims that pop up for that 20 years in which I own the property. Anything that's happened prior to that, previous owners, I'm not going to do anything. There is no guarantee of warranty or indemnification prior to my ownership. All right, let's talk about a grant deed. A grant deed is a document that transfers title, just like the previous deeds that we've talked about. However, when using a grant deed, the grantor only makes 2 warranties. Number 1, that the grantor has not transferred title to anybody else. And number 2, there are no title defects or encumbrances that arose during my time as the title holder or during that grantor's time that they held title. It's similar or like a special warranty deed, where the grantor is giving no warranties to any claims that may have arisen prior to the grantor's ownership. We just talked about that during the special, when I described the special warranty. All right. So there's no promise to pay legal costs or defending any title claims that happened prior to that. So what's the difference then between a grant deed and a special warranty deed? And the answer is, it depends on the state that you're doing business. In many states, they don't call it a grant deed. They call it a special warranty deed. In other states, it's not called a special warranty deed. It's called a grant deed. Grant deed and a special warranty deed are essentially the same thing. It's just they're titled something different. Next deed I want to talk about is a bargain and sale deed. All right, it's a document that transfers ownership. We know that. But this deed includes a warranty that the grantor has title, meaning they have ownership to the property, but does not guarantee that the property is free from any title defects or any encumbrances. All right? So yes, there's ownership interest, but there are no warranties against any other kind of lien, such as a mechanic's lien or a child support lien or something to that effect. Now, this is commonly used when a property is sold at a foreclosure sale, a tax sale, or it's used during the settlement of an estate of a deceased person's. And again, a lot of this will depend on the state in which you're doing business. All right, so the next deed I'm going to talk about is a quitclaim deed. Now, I just want to make something clear here. It is not called a quitclaim deed, Q-U-I-C-K. It's quit, Q-U-I-T, quitclaim deed. All right? It transfers title. It's a document or a deed that transfers title. But here's the thing about a quitclaim deed. It essentially says that I am the grantor. I may or may not have ownership. I don't know. But if I do, if I have any ownership interest or if I have any interest at all in any capacity, if I do, here you go, you can have it. So there are absolutely no warranties given whatsoever. It's just simply saying that, hey, if I have any interest in this property, whether it's an ownership interest, whether it's a legal right of possession or anything else, if I do, and I'm not saying I do, but if I do, you can have it. Now, quitclaim deeds are commonly used to transfer ownership or interest of a piece of real property to family members. We see this a lot with ex-spouses where, according to the divorce decree, one spouse is going to transfer their interest to the other. We do that by a quitclaim deed. In some states, a quitclaim deed is used to correct any errors that were discovered in the previous deed that transferred title, such as misspelling of names or correct a legal description. Those are the purposes and the uses of a quitclaim deed. Remember, a quitclaim deed. I have some interest. I don't know what. I don't know how much, but here you go. If I do it all, no warranties whatsoever. What is a gift deed? Well, again, it's a document that transfers title, but gift deeds are typically used to transfer title between living family members. So maybe I want to transfer title to a piece of real property that I own to my son or my daughter. All right. Gift deeds are also used to donate a piece of real property to charities, a nonprofit charity. It allows title to be transferred to my son or daughter or a family member or to this nonprofit agency without any monetary consideration. And the deed will stipulate something to the effect, and a lot of this is based on state law specifically, but in essence, the deed will state in consideration of love and affection for a son or daughter, in consideration of love and affection to the Catholic Church or whatever nonprofit organization they are donating this property to. Now, a gift deed may or may not contain warranties, and that's actually at the discretion of the grantors, okay? So we use a gift deed when we're gifting a piece of real property to a family member, a close friend, or a nonprofit organization. All right, so what is a release of deed or a deed of release? It's commonly used when a lender agrees to remove the lien against the property that was there as a result of a mortgage. That's all it is. It's just where the bank is removing their their lien against an asset. And it's that simple. Okay, what is a corrective deed or what we call a correction deed? Well, if there is a mistake in the previous deed that was filed at the courthouse or recorded at the courthouse, there has to be a mechanism to make those corrections. So maybe there was a misspelling of a name, the legal description, there was an error. Some states, they use a quitclaim deed. In other states, they use what's called a correction deed. So once a deed has been recorded, it is a permanent part of the public record, and it cannot be changed. You can't go back and change that particular deed that initially transferred title. So we use a correction deed to amend that record by executing a new deed. It's called a correction deed. All right, and I've outlined it on your screen for you. So this corrective deed actually confirms the covenants and the warranties and the restrictions and everything of the prior deed. It does everything that the prior deed did. However, it just contains the corrected information. All right, that's it. That's all a correction deed is. And again, it's commonly used to correct mistakes that the previous deed had, such as misspelled names, incomplete names, wrong or missing middle initials, or the omission of a marital status, those type of things. So what is a cession deed? Well, a cession deed is only used to transfer title. Remember, title in real estate means ownership. So it's used to transfer title of real property from a private owner, private citizen that owns property, to a government authority. So for example, maybe there is a subdivision that's owned by a private investor, a private developer, but the city that subdivision is located in is going to annex that property. So what's going to happen is the common areas, such as the streets, maybe the park, those type of things that are going to belong to the city, we're going to use a cession deed. What you have to know for your exam is a cession deed is used to transfer title of real property to a government authority. In some states, a cession deed is also used to transfer title to that government authority when Escheat is used, or when eminent domain is used. Number 135, what's a sheriff's deed? Well, a sheriff's deed is generated when real property is transferred as a result of a sheriff sale. So in states where sheriff sales are used, there's going to be a sheriff's deed that is generated. So let's say, for example, you live in one of those states and there is a judgment that's placed against your property that forces the sale of that property to pay off that judgment or that debt, or maybe you default on your mortgage payments. What's going to happen is a court order is going to be given to the county sheriff's department, who is going to schedule a sheriff sale. It's like an auction, if you will. And then whoever buys that property at the sheriff's sale, which could include the original, in the case of a mortgage company, the mortgage company is actually going to send a representative there in case no one shows up. So then the lender is going to basically end up with that property. So what's going to happen is the sheriff's department will issue a sheriff's deed to the winning bidder who purchased that property at the sheriff's auction or that sheriff's sale. So a sheriff's deed is generated when there is a sheriff's sale that's been conducted by the county sheriff in order to fulfill a judgment or a foreclosure. Administrator's deed. That's used to transfer title of real property of a person that has died intestate. When somebody dies intestate, they have died without a will. And so that administrator of the estate that's going to transfer property or title to the descendants, like the children or the grandchildren of the deceased persons, they're going to use use an administrator's deed to transfer that title. The key here is when somebody has died without a will. All right, that's key to remember. All right, so let's talk about a tax deed. Now, before I can really tell you about a tax deed, you have to understand the process behind a tax deed. If you live in a state that levies real estate taxes against your property and you don't pay your real estate taxes, depending on the state that you live in, there's going to be one of two processes that the county's going to use to get their money. The first one is a tax lien certificate auction, where if you owe $1,000 in property taxes, they're going to sell off at an auction. They're going to sell a tax lien certificate, and bidders are going to show up at the auction and buy that certificate. That's one way. We're not talking about that in this video insofar as a tax deed. Other states have direct tax deed auctions. So they don't do the tax lien certificate, they actually do the tax deed process. So that means if you owe $1,000 in property tax and you don't pay it, the county's going to schedule an auction. Your property is going to be put up for auction for the amount that's owed in real estate taxes, and the successful bidder is going to get a tax deed from the county. So the county is actually and legally going to transfer title from you to the successful bidder using a tax deed. Okay? Now, in some states, there is what's called a right of redemption. It's a certain period of time where the original owner that lost title can redeem that property. Because remember, as soon as the county transfers, using the tax deed, transfers title to the successful bidder, that successful bidder owns the property. They hold title. You have lost ownership to your property. But depending on the state, many states have what they call a right of redemption period. So you may have 6 months, a year, 2 years, whatever the state law is, to go back to that, to go to the tax deed holder, the person, that successful bidder, and say, okay, here is your original investment plus whatever the interest is, the penalty interest, and then that person has to then transfer title back to you. Not every state has it, but you have to remember there may be, the transfer of title may be subject to a right of redemption. Now, when the county transfers title to the successful bidder using a tax deed, there are no warranties that are given. So that investor that's going to show up at the tax deed auction, they have to make sure that they do their due diligence, because when that title is transferred using the tax deed, if there are liens, child support liens, IRS liens, or anything else levied against the property, that new owner inherits all of that. All right, the next type of deed I'm going to talk about is an executor's deed. This is used by the executor of an estate, meaning someone has died with a will. They have named the executor of the estate, and as that executor is transferring title of real property for that deceased person, they're going to use what's called an executor's deed. Number 139, what's a guardian deed? Well, it is possible for a minor child or someone that is been declared incompetent for whatever reason. Maybe they are medically incompetent, and someone has legal guardianship over them. Or in the case of a minor, there's a legal guardian. There has to be a way for those persons that own real property to be able to transfer title. So, for example, maybe a minor child has been willed some property. Well, the legal guardian has decided to sell that property on behalf of the minor child. The type of deed that's going to be used is called a guardian's deed. Number 140 is a trustee deed. This is used to transfer title of real property out of a trust. So if the property is being held in a trust, and then that property is going to be released from that trust, we transfer title to the grantee using a trustee's deed. So a deed of reconveyance is used to transfer title of real property from the trustee to the trustor when a deed of trust is used as collateral for the property and the loan. Last but not least, number 142, a deed of trust. What is a deed of trust? Well, I'm not going to explain or discuss it in this video. It would take me 10 or 15 minutes. I did a previous video on a deed of trust and everything that you have to know about a deed of trust, not only for the real estate career that you're about to get into, but also as a student studying for their real estate exam. It is that important. So check out the deed of trust in this video right here in the box. All right, that's all I got. I'll see you all in the next video.